Hello, my name is Dan McGookey and welcome to this week's version of Foreclosure Stories, a series of videos that we started several months ago meant to educate you, the American public, about your mortgages, which could make the difference between saving and losing your home. This week's story is about Laura, and we call it Leaving No Stone Unturned. What we mean by that is that sometimes in foreclosure cases it's necessary to conduct what's called a discovery deposition, which is a procedural device within the court system allowing both sides, in any kind of litigation for that matter, not just foreclosures, but to take the deposition of a representative of the other side and find out information about the other side's case and find out information, quite frankly, about your own case. In Laura's case, we did this about 3 weeks ago, and it worked out quite well in the sense that we exposed a number of facts that we feel are going to prove extremely significant and extremely helpful in getting Laura a great loan modification. As in almost all of our cases, Laura's case has two components as far as defenses, two major categories of defenses. The first is standing, and the second is what we call the equitable defense. Talk about standing for just a few minutes here. Standing is basically the legal way of saying, pointing back at the bank who's seeking foreclosure and saying to it, prove that you are the right party to be seeking foreclosure against this homeowner's home. And then in the day and age of loan securitization, where promissory notes and the loans have changed hands so many times, it can be very difficult for a bank seeking foreclosure to prove that it is the correct party to be seeking foreclosure. In Laura's case, specifically what we developed through the discovery deposition is that there were two versions of the promissory note, which could prove very troublesome for the bank. The first version had no endorsement. It was just made payable to the originating lender. The second note that was produced had an endorsement in blank, meaning like a blank check. It makes it so-called bearer paper. Now, the fact that there's two materially different notes is very significant because the burden is on the bank to prove that it is the holder of the note and the one and only original note. The other component of the standing defense that was exposed nicely in the deposition in Laura's case was the fact that the bank could provide virtually no proof as to what we call the chain of custody of the note. That is to say, who all held the note, who touched it, in what vault was it sitting from the day after Laura signed it years ago to the present day, that day of that deposition. There was no proof that this promissory note was the one and only note that was signed by Laura that day. As to the equitable defense, we developed several interesting and I think important facts and very helpful facts for terms of getting a great loan modification for Laura, and that is, first of all, there were some serious questions about whether the bank applied Laura's payments correctly. We see this often, and I call it servicing fraud. The servicer is paid as a percentage of the unpaid loan balance, keep that in mind, so that if payments are misapplied, the servicer and then interest and late charges are added onto the loan balance, the servicer is actually making more money. So we see this quite often where the bank is not applying the homeowner's payments correctly, causing the loan balance to go up unfairly, increasing the bank's fees. So that was present in Laura's case, and in addition, the bank had indicated to Laura before the foreclosure that if she made 2 payments, she would be caught up on her loan. She made those 2 payments as requested. In fact, instead, rather than getting her loan reset and back on her way to paying off her loan, she got a foreclosure complaint. That is a great equitable defense now to argue to the court that foreclosure is inappropriate. Finally, Laura's loan was FHA insured. That's the Federal Housing Administration. FHA has a very specific rule and a very important rule that before the bank, who is a loan servicer, files foreclosure, they have to offer what's called a face-to-face meeting. That is an opportunity for the homeowner to come in and sit down and meet with a bank representative face-to-face and discuss the mortgage issues. In Laura's case, the fact that the bank didn't do that is critically important, because chances are quite likely that Laura could have worked things out with the bank, avoiding foreclosure altogether. The fact that the bank didn't meet the necessary precondition of offering Laura face-to-face foreclosure is so significant in that to the extent that it requires the court to dismiss the case. And so we feel very confident that if in fact we do not get a great loan modification in the next month or so from Laura's bank, we'll just move for a dismissal, which we're confident the court will do. Now, that's not what we're looking for, but it's another defense that we're using against the bank to bring it to the table, act fairly toward Laura, and get her situation resolved. So the lesson in this week's story, hopefully for all of you homeowners out there, is this: don't leave any stone unturned. Chances are there's a number of defenses that could be very helpful in your fight to save your home. If in fact you're acting in good faith to save your home, you've got a reasonable ability to pay on your mortgage, chances are quite likely you should not lose your home to foreclosure. And we're very confident Laura's not going to lose her home to foreclosure. Thank you for tuning into this week's version of Foreclosure Stories, and please come back next week. Thank you.